Well, good afternoon, everybody. Welcome to the FTB case law update webinar. We're just going to give a few more moments for people to join on, and then we'll get cracking. Good afternoon, everybody. Again, we've got north of 450 participants booked for this webinar, so I'm just going to allow a few more moments for the numbers to come up to a level to start at. Well, good afternoon, everybody. Welcome to the FTB case law update, the latest in FTB's, I'm now going to use the word acclaimed series of webinars, which we've been running since the beginning of lockdown and are now a regular fixture of the legal calendar. Thank you all very much for participating. I'm pleased to say that today, doing our case law update, we've got two of FTB's juniors, Esther Drabkin Reiter. Hello, Esther. And Jonathan Welch, who, having been in chambers a while and seen a variety of our juniors come through, I can say without fear of contradiction that these two are going to be superstars of the bar in a very short period of time. Esther joined chambers in 2019. She's already making a name for herself in the planning bar. She's already, and this vexes me as it took me absolutely ages to achieve this distinction, she's already appeared in the Supreme Court in the extremely important Kent CPRE litigation about costs, which will be an authority which will attract the attention of many a developer and sort of protester group on those key issues of costs. And as I say, I've worked with her on a number of occasions, and she is going to be one of the very best. Jonathan Welch, I suspect, also forms into that category. Joined chambers just last year in 2020, already developing a very busy practice, and he notably is already engaged in some of the most prominent litigation of the day. He's been involved acting for HS2, helping them obtain injunctions against the various protesters in the sites, including the site at Euston where Swampy and his mates were all dug underground. And as he tells me, there's no lack of demand for that particular kind of service given the nature of the HS2 project. But he's also heavily involved in a number of other major planning schemes. So, as I say, two of our most talented young juniors, they're going to take us through a run of the most important recent cases. Jonathan is going to start, and I think perhaps without further ado, I should say, let's crack on with it. We will have a question session, I hope, at the end, unless our timings go hopelessly awry and you've all left. So if you want to put a question to us, then just add it on the Q&A function in the usual way. But without further ado, I shall sign off and hand over to Jonathan to start.
Well, thank you very much, Andrew, for that generous introduction, and good afternoon, everyone. We're going to be talking through the following fairly long case law in a fairly short space of time. So we've set ourselves a fair old challenge here to take on some of the more significant and impactful cases from the last year. And the first one, which I'm going to cover, is ClientEarth and the Secretary of State and Drax Power. And this case concerned a challenge to a development consent order under the Planning Act 2008. And the application underlay that was an application for new gas turbines, so new fossil fuel power generation, which always attracts controversy. And indeed, in this case, ClientEarth had made significant submissions to the examining authority, which were in some part accepted. However, the Secretary of State departed from some aspects of the examining authority's recommendation, and the Secretary of State made the development consent order. ClientEarth came back for another go and challenged that development consent order. And I think it's important to start by noting that we're in the world of the nationally significant infrastructure project regime under the 2008 Act, where interpretation and application of the national policy statements is of utmost importance, and indeed was so in this case. So the issues then, there were various issues pursued in the High Court, which led to the dismissal of the judicial review. Some of those issues were not pursued again in the Court of Appeal, but the three main issues that came before the Court of Appeal were these. The first two concerned the interpretation of the National Policy Statement EN1, and first of those was the policy statement's approach to need and the contribution to meeting need. The second was the approach to greenhouse gas emissions and reliance on other regimes and mechanisms for controlling those, and the approach that should be taken by a decision maker to such emissions. And the third ground of challenge then, ground of appeal, I should say, was concerned the application of the balancing exercise, the broad balancing exercise under section 1047 of the 2008 Act, and specifically how that related to section 1043, amongst others, and the policy statements. So the court's decision then was, in terms of the first ground, which in a way is the most significant, I think you have to step back and remember that one of the purposes of the 2008 regime was to put the arguments about the need for particular types of national infrastructure, to front load those arguments to the policy making stage, so the national policy statement stage, and not require arguments back and forth over need at the development consent order, the consenting stage. Nevertheless, EN1, para 3.2.3, which I've put the reference up there, which talks about giving weight to the contribution, proportionately to the contribution that a particular project makes to meeting the need. So the question arose in this case as to whether that assessment required a quantitative assessment of the need. And the court said, no, it didn't. It said this paragraph did not require that, and that the weight to be given to need in a particular case is not immutably fixed. And what is proportionate is a matter of judgment. In some cases, the examining authority could undertake a quantitative assessment, but it did not need to do so. And in this case, it didn't have to do so. And indeed, the Secretary of State's mind was open properly to the possibility of reducing weight to the project's benefits as a result of the proportionate contribution it made to meeting the need. The second ground, which again was dismissed, was again to do with policy EN1, policy statement EN1, and the court held that carbon emissions and greenhouse gas emissions are not necessarily themselves an automatic obstacle to consent, but they may be taken into account by a decision maker in reaching a decision. And in fact, and this is contrary to what the High Court had said, which is why it's interesting to see the Court of Appeal's judgment, such matters may carry decisive weight. The High Court had said that CO2 emissions and the like could not carry decisive weight in accordance with what EN1 said, and the Court of Appeal took a different approach. And then the third ground of challenge, which again was dismissed, ground of appeal, which was dismissed, was to do with Section 1047 and whether the Secretary of State had effectively fettered her discretion, because Section 1047 is the broad balancing exercise, having already looked at the policy statement. So the question was whether she had fettered her discretion under 1047 by having regard again to the policy in the energy national policy statements, which had regard to under a different part of Section 104. And it was held that she had not fettered her discretion, and it was perfectly proper under 1047 to have regard again to the policy statements and the relationship of the project to those. I'm then going to turn to the second case on the list, which is Holborn Studios Limited and Hackney. And this is a case from last year, which was Mark II, and it says number 2 there because there was a previous judicial review of a decision for a similar project, and this concerned redevelopment of a building in Hackney used as a photography studio. And that first grant of permission had been quashed. And this second judicial review concerned largely the availability of a viability report and viability information before planning committee and by the public. The issues then in this case were largely the extent to which viability reports need to be made public. And this is why this is of quite some interest and importance to both developers and local authorities. There were other grounds to do with administration of committees, which I'm not going to touch on. I'm going to focus on this point about viability. And the statutory obligation, the provisions of which I've given there, are for background papers under Section 100D to be disclosed. But there are provisions for exempt information under Schedule 12A, and those can include information relating to financial and business affairs of a person, but those exemptions are subject to a public interest test. And then I've referred there to the Perry case, which was from 2014, where the High Court had held that a slightly similar situation, really, that the viability report was presented to the local authority to support a non-policy compliant scheme and affordable housing offer. And it was submitted in confidence. And the conclusion that the court reached in the Perry case was that there was no common law right of access and the information was clearly confidential, and said that, in fact, the disclosure would frustrate the intention of the Local Government Act's intention to allow councils to negotiate. And the public interest balance was not really covered in that case. What has happened since that case, however, is the most recent NPPF and PPG, which give a very strong policy steer, para 57 of the NPPF and a paragraph of the PPG, that the starting point is that such assessments should be publicly available because transparency is an aim of policy. And that it can't be assumed now, following the recent policy update, that because something is related to viability, it automatically falls into confidentiality protection under the Local Government Act exemption. So the difficulty we then had with this case was the approach to be taken in the light of those changes to the viability report, given what the High Court had said in Perry. I should also say there that there were difficulties in the published data in this Holborn Studios case, that it had some inconsistencies as well. But the significant point of this case was that the court found the Section 100D obligations had not been complied with, and the approach to the exemption for such information was not correctly approached. And the planning guidance now sets out clear principles that should be followed, with standardized inputs for viability assessments, which is an argument for another time, perhaps, because that may cause some difficulties. and that such viability reports should be publicly available. So to that extent, the Perry case is overtaken by the PPG, and now, of course, by Hoban Studios. And there's now pretty much a presumption following the Hoban Studios case that information on viability reports should be publicly available except for exceptional circumstances. However, as I referred to at the beginning, this is not a completely unfettered and unlimited obligation of disclosure. There is a public interest test to be considered. But nevertheless, it must be demonstrated that that test has been actually approached properly in the light of the PPG. And this, of course, has implications beyond viability, because there's other would-be exempt information which it may be argued should not be disclosed to the public and the full committee. But this case certainly shifts things towards, as I said, pretty much a presumption that things should be disclosed unless that public interest test is satisfied under those exemptions. There were various aspects that were not entirely decided, which I've referred to there at the end in the case, which perhaps are matters for another time, as to whether this test for disclosure should be focused on the need for an adequate response to be able to be made to consultation, and also a legitimate expectation ground. I'm going to pass over now to Esther, who will take us through, first of all, the City and County Bramshill case.
Thank you, Jonathan, and thank you all for joining us on such a beautiful day. It's great to see so many of you with us. So yes, I'm going to deal with 4 cases before handing you back to Jonathan. First, the City and County Bramshill case. And this concerned the redevelopment of and around a Grade 1 listed mansion and a Grade 1 registered park and garden, which had previously been used as a police training college. As you can see, there were a huge number of appeals that the inspector had to deal with in first instance, both against refusal of planning permission applied for by City and County and against enforcement notices in relation to development already carried out. Some of those appeals were granted, some were refused by the inspector, and City and County successfully challenged some of the refusals in the High Court. The appeal to the Court of Appeal concerned the refusals in the High Court which weren't overturned by the High Court. And you can see there on the slide the 2 main issues in the appeal, namely the interpretation of NPPF policy on isolated homes in the countryside and the assessment of harm and benefit to heritage assets under Section 66 of the Listed Buildings Act 1990. In the event, the Court of Appeal upheld the inspector's decision dismissing the appeal and considered that the inspector had applied relevant policy lawfully. The inspector's reasoning was described as impeccable and unimpeachable on multiple occasions by the court. So if we could go to the next slide, please, Jonathan. So on the concept of isolated homes in the countryside under paragraph 79 NPPF, the Court of Appeal confirmed that this is a concept of planning policy, not law, and therefore doesn't lend itself to rigorous judicial analysis. And in doing so, it referred to the recent Supreme Court decision in Sam Smith and the limited role for the court in interpreting concepts of policy rather than law. It also affirmed the interpretation that had previously been taken in the case of Braintree of the equivalent paragraph in NPPF 2012, and that interpretation is set out for you on the slide. The question of whether the development is an isolated home in the countryside relates to whether it would be physically isolated in the sense of being isolated from a settlement, and not whether it's remote from other dwellings. And both of the concepts of isolation and settlement are matters of planning judgment for the decision maker. The court noted that if one adopted a test of remoteness from other dwellings, as the appellant was urging, this could undermine the aim of promoting sustainable development in rural areas. For example, you might have a situation where in a proposal for 2 new homes in an isolated area, each new home was used to justify the other. Then turning to the court's discussion on Section 66, and this revolved around a practice that has arisen in recent years of adopting an internal heritage balance before the paragraph 196 NPPF Balancing Act is undertaken between heritage harm and the wider public benefits. And the court held that this internal or net heritage balance was not legally mandated and was not required as a result of the Palmer case. It's possible for an inspector to take that approach, but it's not required by law. And it explained the decision in Palmer in that, having considered positive and negative aspects of any heritage impact, a decision maker may legitimately find that there is no harm to heritage assets, for example, where mitigation would avoid harm. But if some harm has been found, then that harm needs to be given great weight in the Balancing Act when it's considered against public benefits. And you may also wish to look at a High Court decision of K, decided shortly before this case, which comes to a similar conclusion. There was also a further interesting comment made on matters of weight in planning inquiries, and as decided by inspectors, the court found that there was no requirement on the inspector to declare any view on weight to be given to particular matter and give the parties a chance to address it, just because she disagreed with the submissions on weight of both sides. So, Jonathan, if we could turn to the next case, please. This is a case of Liverpool Open and Green Spaces Community Interest Company and Liverpool City Council. And this concerned planning applications for residential development on council-owned land in a park, Calderstones Park, and the relocation of a miniature railway. And the development was also proposed next to two, or in the vicinity of two listed buildings. The grounds of appeal related to the interpretation of green wedge policy, which is related to green belt policies, and this, again, the Section 66 heritage duty. But there was a prior issue in the Court of Appeal, namely whether the appeal was academic, and the court considered that it should hear the appeal on the basis of the wider public interest in settling the interpretation of policy OE3, which was the green wedge policy. In the event, the Court of Appeal allowed the appeal on the green wedge ground and dismissed it on the Section 66 ground. But as it was necessary for the appellant to succeed on both grounds for the quashing of planning permission, which the High Court had already undertaken to be overturned, that did not happen. So next slide, please, Jonathan. The case helpfully sets out some general principles from recent cases for the interpretation of green belt policy and, in this case, green wedge policy. Again, we see this concept of policy, not law, as in the previous case, in relation to the concept of openness, which you will recall from the Sam Smith case is an open textured concept. And its meaning needs to be derived from the words the policymaker has used, read sensibly in their proper context, and not as if they were the provisions of a statute or contract. So again, the court is saying it has a limited role for interpretation with these kinds of contexts. The application of the policy is a matter of planning judgment and involves realism and common sense, and an unduly legalistic approach should be avoided. The court affirmed case law, suggesting that visual effects of development can be relevant to whether it preserves openness, but this is a matter of planning judgment. And it again emphasised the importance of context when interpreting the policy, and in particular considering which policies sit around it. So applying this to the interpretation of the green wedge policy, the court noted that there was no test of very special circumstances in that policy or a very strong presumption against development, as there is, for example, in greenbelt policies, and that the officer was entitled to conclude that an increase in built development would not affect the predominantly open character of the green wedge. This is quintessentially a matter of planning judgment and could include visual effects. Furthermore, the officer was also entitled to assess the impact on the green wedge on the basis of the proportion of the green wedge that the site represented. And if we turn to the next slide, briefly on the Section 66 duty. So in this case, there had been a failure to refer to the consultation response of the council's urban design officer, who had expressed strong conservation objections to the scheme, and these were not set out in the officer's report. And the court found that this was a failure to have regard to an obviously material consideration, and it was also a breach of the Section 66 duty to have special regard to preserving heritage assets, preserving the significance of heritage assets. So this is a particular issue in heritage cases, and it's not the first case that this kind of argument has been successful. In the case of Loader, the officer's report had indicated that the Victorian Society had been consulted when in fact it hadn't, and that was also an error of law which was sufficient to vitiate the planning permission. It's something that has arisen in one of my cases recently as well, where ultimately the defendant local authority conceded the case on the basis that a heritage consultation response had not been reported in the officer's report. So it is something to be wary of, particularly in these heritage cases, for both developers and local authorities. Really make sure that the officer's report properly reports any objections and any responses on heritage issues. Now turning to the next case, the Hillingdon case relating to ecological mitigation for the HS2 development. And this case related to the Colne Valley Viaduct South Embankment wetland habitat, which was proposed as mitigation, and was a challenge to the Secretary of State decision to grant approval for that for the plans for that habitat, when the approval had previously been refused by the London Borough of Hillingdon. And that refusal had been given on the basis that HS2 had provided no information or evidence on the impact of the works on archaeological remains. HS2 argued that it would undertake the assessment itself at a later date. There were 4 stages of decision-making prior to the Court of Appeal decision. So first, as I already mentioned, the planning committee rejected the application. That rejection was upheld by a planning inspector who also considered that no evidence had been provided. The Secretary of State, however, rejected the recommendation of the planning inspector and essentially came to the view that the local authority simply had to accept the application without any evidence or supporting information, a decision which was upheld by the High Court. The Court of Appeal allowed the appeal, upholding the planning committee's initial decision to refuse approval. So we go into the decision in a bit more detail on the next slide. The main issue between the parties related to the effect of statutory guidance and environmental minimum requirements, which were part of the documentary framework between the Secretary of State and HS2, in which the proposals were being delivered, and whether those guidance documents had an effect on the decision-making powers of the local authority under Schedule 17 of the HS2 Act. And the Secretary of State and HS2 argued in very simple terms that the guidance significantly cut down the powers of the local authority to withhold approval for such mitigation works. Essentially, as long as HS2 said those works would comply with the statutory guidance and the environmental minimum requirements, the local authority could not withhold refusal. As the court put it, the argument was that the effect of the EMRs, the environmental minimum requirements, was to oust the duty of the authority under Schedule 17 to consider, in the case of works affecting archaeological remains, whether the design of works ought to be modified or if the works could reasonably be carried out in a different location. If we move on to the next slide, the Court of Appeal disagreed with these arguments, and very helpfully, they summarise their findings at numerous points in the judgment. So if you're going to look at this judgment, then paragraphs 10 and 68 to 70 are the main ones to look at. Effectively, they construed the Act as a balance between the public interest in delivering HS2 in a timely manner with the democratic need to ensure that local environmental and planning concerns are protected. And this led to a finding that the duty to assess impact, for example, on archaeological remains, was imposed squarely on local authorities by the Act, and they could not delegate it to other parties such as HS2. And the court also came to the perhaps obvious conclusion that guidance, a non-legislative instrument, was not capable of altering the content or scope of the legal duty. This also potentially opens the door for wider arguments in other planning contexts, that the question of whether sufficient information has been provided to enable the decision maker to make a decision is a question of law. So it's one for the court to decide, rather than the decision maker itself judging whether sufficient information has been provided. So now turning to the final case, I will be discussing in detail Leech Homes, which is concerned with compensation in compulsory purchase cases, and in particular appeals regarding certificates of appropriate alternative development. And this arose in the context of greenbelt policies. The appellant Leech Homes, their land had been compulsorily acquired for the Morpeth Northern bypass, and they argued they should get particular compensation on the basis that they would have gotten planning permission for under a certificate of appropriate alternative development for residential development on the site. This application was refused by Northumberland County Council in the first instance on the basis that no such planning permission would be granted, and upheld by the upper tribunal exercising an original jurisdiction. The crux of the decision turned on whether the land was land to which Greenbelt policies applied. And by the time the case got to the Court of Appeal, it was agreed that if the Greenbelt policies did apply, planning permission would have been refused. If they did not, planning permission would have been granted. The next slide, please, Jonathan. The problem here was that the only policy on Greenbelt in the local development plan, in the development plan that was applicable, policy S5, the sole survivor of the Northumberland County and National Park Structure Plan, provided for an extension of Greenbelt, but didn't set the precise boundaries of that extension. Those boundaries were to be set in the local plan, but had not yet been defined. And the Court of Appeal, in such a situation where you have a general policy indicating a Greenbelt area, but no precise boundaries, set out a two-stage process for determining whether such land can be said to fall within the Greenbelt. First of all, it held that policy S5 does have the effect of establishing Greenbelt, and where land falls within the ambit of such a policy, in principle, the Greenbelt policies apply, or there's an assumption that they apply. However, such an assumption or principle can be rebutted where there is a sufficient reason in the view of the decision maker for concluding that when those boundaries are determined in the local plan, the land will be excluded from the Greenbelt. So step one essentially is a question of interpretation of policy. Step two is a matter of planning judgment for the decision maker. And they held that the Upper Tribunal and Northumberland County Council were right in their planning judgment. The court drew on and affirmed another recent decision on this issue, the case of Wedgwood and City of York Council, decided last year. That related to an application for planning permission, and the fact that they applied those the principles in that judgment suggests that this case is also of wider application, bearing in mind the different nuances between a CAAD application and planning permission. There's also an important procedural point on costs to be aware of in this case if you are dealing with certificate of appropriate alternative development appeals in the upper tribunal. So the appellant had challenged the award of costs made against them, and the court allowed that appeal. There's no general power to award a council its costs where a refusal of a certificate is upheld unless the landowner has acted unreasonably. So just one to be aware of if you are advising or dealing with costs in these kinds of cases. And now I think I'm turning back to Jonathan to deal with two more cases.
Thank you very much, Esther. Yes, the first case I'm going to deal with then now is a case about conditions from the Court of Appeal called DB Symmetry. And the underlying application, the development was a large urban extension, a very large urban extension to the east of Swindon. And essentially that planning permission had been granted subject to an apparently unlawful condition which required dedication of certain land as a highway without compensation. So the issues that the Court of Appeal had to consider were first, whether the planning condition required the dedication of the road as a highway, or whether it merely regulated the physical attributes of the road. So that was a question of interpretation. And second, what approach the court should take as a matter of principle to the validity or validation principle of interpretation in this case. The decision that the court reached then on this was that they construed the condition by reference to a reasonable reader. So they interpreting the planning condition as a matter of asking what a reasonable reader would understand the words to mean in the relevant context, including the purpose of the consent and other conditions and documents that were relevant. And the court held that the reasonable reader would be disposed to understand that in imposing conditions, the local planning authority had complied with the law and government policy, and the court would not, or would be slow to suppose that the local planning authority would have intended to grant planning permission subject to an invalid condition. The court considered the validity or validation principle in relation to the interpretation of planning permissions more generally, and held that where the court is faced with a choice between two realistic interpretations, it will prefer an interpretation which results in the instrument in question being valid as opposed to void. And the court drew on some more general recent Supreme Court cases of Enker Insat and Insurance Company from the last couple of years in the Supreme Court. The court concluded that the condition in this case could not lawfully require a developer to dedicate part of his land as a highway without compensation, in accordance with the case of Hall and Co. and Shoreham, which is a case from 1964, some time ago, and one might comment as an aside that things have moved on since then, and perhaps that principle may be revisited. Indeed, the Court of Appeal perhaps suggested as much by saying this is the authority, this is the principle at this level, as in the Court of Appeal level. And the court held a condition that requires a developer to dedicate land which he owns as a public highway without compensation would be unlawful. As I said, the court noted that whilst the interpretation of the condition adopted was the most natural conclusion, it would lead to an unlawful condition. If it would lead to an unlawful condition and therefore avoid planning consent, if it wasn't severable, that would be because of Hall, which precludes dedication without compensation. So it will be interesting to see if this is indeed at some point in the future an issue that is taken higher than the Court of Appeal, with a party seeking to overturn the approach in Hall and Shoreham. So I then turn to the next case, which is Blackbushe Airport and Hampshire County Council, with the Open Spaces Society intervening. And this, as you can hopefully see from the background photograph, is an airfield or an airport with runways and a terminal. And it was registered as common land, which, as you may well be aware, places certain restrictions on the ability to develop that land. So an application was duly made to deregister the part that was registered as common land. And that application to deregister was on the basis that the land was within the curtilage of the building being the terminal building, and that being a ground for deregistration. So the question was, as the airport owner claimed, 115 acres that formed the operational part of the airport, they argued it could be deregistered on the basis of a fairly small two-storey terminal building compared to the 115 acres. And the inspector at the inquiry had accepted the airport's argument and indeed deregistered, but this was to be overturned by the High Court. And as we'll see, the issue in the case was the approach that should be taken to curtilage. And why we've chosen this case is because curtilage has application beyond the rather wonderful world of the Commons Act 2006. It has application in the NPPF, in the definition of previously developed land, and also, of course, in the Listed Building and Conservation Areas Act 1990. So it's an important word, curtilage, and this case, I would suggest, if you're looking for a good treatment of it, is about as good as it's going to get. It really goes through all the authorities and gives a good steer for those, not only the sort of hard questions of law, but also how judgment can be applied to whether a bit of land is within the curtilage of a building. So the error of law that the High Court and the Court of Appeal identified was that the inspector had applied the wrong test, essentially. And the inspector had asked himself whether the land and the building together formed an integral part of the same unit. Whereas instead, the inspector should have asked whether the land in question, which is the runway, fell within the curtilage of the building in question. So there was an error of law in the approach that was taken. And in terms of the definition of curtilage, the court said curtilage is like, said it's one of those words that's a bit like an elephant. You know it when you see it. And it didn't give a prescriptive definition of what is the curtilage, but it said it's easier to say what is not the curtilage of a building. In any event, some helpful steer is given that land must be sufficiently proximate to the building in question, and it must be an integral whole, and also that size is not necessarily determinative. So in this case, the 115 acres as against the relatively modest sized terminal building, that was not necessarily something that as a matter of law meant it could not be the curtilage. It's always a matter of judgment, and it's fact specific. Now, what's really interesting about this case, I think, from a sort of more ordinary planning point of view, is that the Court of Appeal took a slightly different approach to the High Court. The High Court had said there is a difference when you come to consider curtilage in the listed buildings context, and there's the Calderdale line of authority. The Court of Appeal didn't have any time for that and said, we see no reason why a different approach should be taken to curtilage in the listed building context. So why I say that is that I think in the light of this decision, there will need to be further thought about the approach that's taken as a matter of course to listed buildings and what is within their curtilage, which is of course a crucial question for listed buildings planning. So an interesting case, and I'm now going to turn back to Esther, who's going to take us through a few brief highlights from some other cases from the last 12 months. Esther.
Yes, thank you, Jonathan. And in the light of the time we have remaining, this will be very brief. We thought it might just be interesting to point out some other cases briefly, which set out some useful propositions. So first of all, we've seen a flurry of cases, appeals on paragraph 11D and the tilted balance. Not too much to say here because essentially the High Court decision was upheld on fairly straightforward grounds in all cases, but I've set out there the propositions that come out of the Court of Appeal's reasoning, which might be useful just for your information. And then if we move to the next slide, just a brief comment on these two cases, which I've loosely grouped together in the category of interpretation of planning permission. So Norfolk Homes emphasises the distinctions between a planning permission and Section 106 agreement. The Section 106 agreement is not part of the planning permission and will usually not be capable of assisting the interpretation of the planning permission. And this case is really important to be aware of. In the case of Section 73 planning permissions, they will not be bound by the Section 106 agreement for the original permission unless it explicitly made provision for that. Or it has been varied by deed. So when you're drafting your Section 106, think about whether there might be Section 73 planning permissions applied for in future. You might want to just put a clause on that in the Section 106 agreement. And then the Hillside Parks case, quite an unusual case, which is quite specific on its facts relating to the compatibility of multiple planning permissions on the same land with each other, and whether a later planning permission might render it impossible to implement, in this case, the original master plan. It is of wider interest because of its emphasis on a holistic approach to interpreting a planning permission and considering it as a whole, which potentially has wider implications for so-called drop-in permissions, where smaller elements of a large, for example, housing scheme are amended by Section 73 permissions in the course of it being built out. So that process will need to be considered quite carefully in the light of this case, whether it's compatible with the original scheme. And the court referred to certain aspects of the planning merits and mitigation of schemes such as highways, landscaping, which will have been taken into account when the original permission was granted and might not be so easily amended in relation to piecemeal development on particular parts of the site. There was an indication that this case would be appealed to the Supreme Court. It's not yet been determined by the Supreme Court, but that's something to watch out for in future. And I think Jonathan's going to speak briefly about procedure now.
Thank you, Esther. Yes, just two very brief cases to finish up from me then. The first is the Gluck case. I apologise, I haven't given the full reference there, but it's Gluck and Secretary of State for Communities and Local Government. And that was, in a sense, a fairly straightforward decision, which establishes that the time for granting prior approval applications, and remember that in many of these cases where there's no response to a prior approval application, it's simply deemed to be granted. The time for granting prior approval applications can be extended by agreement in writing. And it's worth noting, however, that the Court of Appeal disagreed slightly about what might constitute agreement. So if you're seeking to do this, it's worth making that agreement as clear as possible and as bilateral as possible. And the next case is Parkdean, which is a case that concerns a very out-of-time judicial review claim over 6 years. And the case, all parties were agreed that there was an error on the face of the original permission. The significant error was that the red line area was massively beyond what was intended. So permission had accidentally been granted for, I think it was a holiday park, a caravan park, for a much larger area in a very sensitive location that had been intended. And that the planning harm in that justified extending the time period for bringing judicial review proceedings by several years. And of the same flavour, you might recall a case from a couple of years ago called Thornton Hall Hotel, which was another case where there was an error, a clear error from an earlier, an out of time now permission, which had granted the applicant more than they deserved. And the court there, upheld by the Court of Appeal, had allowed an out of time judicial review claim. So Parkdean is another reminder that in these exceptional circumstances, and I think they do have to be exceptional circumstances where there's something pretty significant like serious planning harm as a result of the error, the court will entertain such out of time, very out of time applications for judicial review, and indeed will indeed grant relief for those judicial review claims. I'm going to pass back to Esther now for a few follow-ups of ones to watch.
Sorry for the slightly tag team approach as we cover the final matters. So we just wanted to draw your attention to some cases which have been heard but not yet decided, so should be on your radar. And Andrew has very kindly already mentioned the CPRE case that I'm involved with about liability for costs at the permission stage. There's another Supreme Court case which was heard earlier this month about when time starts to run in neighbourhood plan challenges. The Court of Appeal recently heard the case of Flynn regarding the controversial Elephant and Castle shopping centre redevelopment, about the scope of delegation by members to officers in planning decisions. And the High Court last week heard a case on the scope of matters that can be dealt with by a statutory consultee. So the argument in that case is that the Highways Authority shouldn't be responding on matters that are really economic matters rather than highways matters.
Excellent. Thank you very much, both. We've got time just very briefly for some questions. Before we do that, I'm just going to add a word about the joys of having to select cases for these sessions, and just to mention that in my view, certainly in terms of dealing with large schemes and one of my particular interests in mineral schemes, that the Hillside case is really going to be important. I believe it is likely to go to the Supreme Court, and the interaction between the whole series of planning permissions that you often get on a large scheme, and in terms of a mineral site when the original permission may have been granted many years ago, is actually extremely important, and the judgment does stray into some very difficult areas. So it will be most interesting to see what the Supreme Court does say about it, particularly I think given the tendency that the Supreme Court has had, particularly through Lord Carnwath, of providing sort of Gordian knot solutions to a lot of these very thorny problems by saying, well, it's all just a matter of common sense and just read the stuff and see what it means. So we shall have to see what they come up with, but as I just flag up, because that is a case that I think is very important. But with that said, and thanks for the very comprehensive coverage of the cases that we've seen this afternoon, let's have a look at some questions now. I think the first will be for Esther, which is from Robbie McNaughter, who asks us to say just a little more about the internal heritage balance point, wondering whether the decision maker is at liberty to come up with as it were, first of all, a heritage balance, say that there's no net effect and therefore no net harm, and therefore no need to balance against public interest, even if the sort of starting point of the internal heritage balance is that there was some heritage harm. Esther, what do you think about that?
So this is Robbie, this is exactly the kind of thing that appellants, promoters of schemes were urging on inspectors, saying, well, look, you know, we are bringing all these heritage benefits, there's a very minimal heritage harm, so actually the net effect is there's no harm, so you don't even need to go into the Balancing Act. And the Court of Appeal said that that's a possible way of dealing with things, but it's not legally mandated. So it's really for the inspector to decide how best to carry out the balance. They did say that it shouldn't really matter which method you use, you should still get to the same outcome. And I think their treatment of the Palmer decision, which really says, well, such an internal balance is only really appropriate where you can mitigate the harm. So there is, in effect, no harm. Where you actually will have some harm, but that's outweighed by the benefits, then it's more appropriate to give considerable weight to that harm and then carry out the Balancing Act.
And the thing I would add is from a decision maker's point of view, that it is incredibly important that you set this out clearly, exactly how you've done it, because there are a multitude of ways of going about this balancing exercise, as Esther's just said. But it's really important that your report or the decision letter sets out clearly exactly how the exercise has been done, so that if it is ever questioned or challenged, there's a clear route to identifying exactly what you have done, so that all of the bits of the boxes are ticked, even if they're ticked in a different order in different cases. Next question I think I will take for Jonathan, relating to the Blackbushe case and listed building curtilages. And he asks, isn't there a temporal dimension to listed building curtilage, in that for listed building control, the reference is to the curtilage at the date of listing? Effectively asking, does the curtilage sort of crystallize and become fixed at the date of listing, never to be changed, or is it a flexible concept as the layout of buildings, gardens and other areas differs over time? John, what do you think?
Yeah, I think clearly there is that temporal dimension, because you're looking at the state of the building and its curtilage at the date of listing, as you say, Chris. Absolutely. However, the way you approach that question of curtilage is something that's going to be influenced by the approach now directed from the Court of Appeal in Blackbushe. I think it's still applicable, even though, yes, as you say, there are some differences with the listed building context, and also, you know, in the NPPF context of looking at previously developed land, that on its face seems a slightly more flexible beast in terms of looking at the land that might be within the curtilage of the building, and that might be something that where there's more variation over time that will make more of a difference to the arguments that are to be made. So yes, the approach to curtilage seems now to be consistent, albeit when it's applied, it will be applied to different points in time, depending on whether you're looking at the Commons Act or whether you're looking at listed building issues, or indeed the PDL part of the definition in the NPPF.
Yeah, I think there's always going to be an inherent tension, isn't there, between the desire to make decisions based on the reality at the time of the decision, rather than some fixed reality which may be sometime in the past, on the one hand, and the desire to have a clear statement of what the position is that is on the public record and can be relied upon by everyone whenever they need it. And so I think it's likely to be something which will come up as an issue. Right. Next then, for Esther, please. Adam Nichols has asked for a little bit more information on the HS2 case, and particularly the details of the information requirements. If you could just tackle that for me.
Yes, so the court did refer at multiple occasions to the adequacy of the information that needed to be provided, and it was in fact agreed between all the parties that the statutory duty to provide information included the duty to provide adequate information. I mean, in this case, on the facts, HS2 provided no information at all. So you might think, just applying the ratio of the case, that it concerned, you know, whether information has been supplied at all, rather than the adequacy. I think it's interesting to note the Supreme Court. If you look at the reasons that the Supreme Court refused permission to appeal in this case, they did say, they implied that some might disagree with some elements of the Court of Appeal reasoning. So while this might suggest quite a broad scope for sort of legal claims on the adequacy of information, it may be that is restricted in due course. But certainly on the face of this judgment, there was a statutory duty to provide adequate information, which can be legally considered.
Thank you. And then, Esther, there's one which has made its way to us through the chat function, asking about the Bramshill case, whether the judgment gives any sort of definition of settlement when assessing isolation. So, for example, a little village in the middle of nowhere in Hampshire, which has just a few houses and more properly called a hamlet than a village, would that, in your view, would that fall within the definition of judgment given to us by Bramshill?
So Bramshill doesn't, and in fact they say it's a matter of planning judgment. So it's going to really depend on the facts of each case. And it's for the decision maker. So it's a context-specific judgment, and it's not one in which the court will intervene.
And then just a couple more general questions rather. First of all, Kevin Brooks asks, in the light of Drax and the general increasing public interest in greenhouse gases, does the Court of Appeal's decision indicate a direction of travel regarding this issue? I have to say, for my part, I'm always rather suspicious of the notion of direction of travel from the courts. There can be interests of policy which come to dominate decisions, but I'm suspicious about saying too much about this is the way a future judgment will go on legal and policy matters. All one can usually say is that there is a particular focus in the policy underlying the decisions which the courts have to make. But yeah, perhaps that's the voice of too much grizzled experience. I wonder whether, Esther, from a more intellectual perspective, you've got a view.
No, I wouldn't add anything to that. I think, Jonathan?
I might just add, I agree absolutely with what you say, Andrew. Just in terms of the Drax case, I would agree. I think the answer to the question is sort of yes and no, but really no. I mean, the Drax decision, the Court of Appeal departed from what the High Court had said, and the Court of Appeal said greenhouse gases can be a reason for a decisive factor for refusing. So in that sense, you might say there's a direction of travel, but actually when you read the judgment, the reason they said that was a simple matter of interpretation of the policy. And they were just interpreting what the policy said, and they disagreed with the High Court about interpretation of policy. It wasn't really to do with the merits of whether greenhouse gases should be a reason for refusal. It was just a question of interpreting what the policy actually said, and they interpreted the policy in line with the usual Tesco stores, Suffolk coastal proper lawful approach to interpretation of policy. So there's nothing particularly remarkable about it, although from the result you might well infer that there is a direction of travel, but I'd agree with Andrew to be cautious about such a phrase.
Yeah, good. And then finally, my friend Dave Bridgewood, who I don't believe to be a betting man, so I think this is a question derived from pure intellectual interest. Would we like to make a prediction on the forthcoming Finch challenge in the Court of Appeal? Esther, go on. You first.
I can't comment on that, I'm afraid.
Good. Well, I think David has tempted us to be indiscreet, and I think there's going to be a collective decision not to be. So we'll just have to wait and see, I'm afraid. Good. Well, thank you very much indeed, everybody. That's been a very, very useful session. Thanks in particular, obviously, to Esther and Jonathan. Really clear, really comprehensive coverage of the most important cases that we've got, and then some really helpful answers, I think, to some of the more detailed questions we've been asked. So on to the next. We look forward to welcoming you at our next FTB webinar. The details are on Chamber's website. There's a recording which will be made available in due course of this one, and also the slides, which you should all have. So thank you all very much, and go and enjoy the sunshine and the relative freedom from lockdown. Thanks all very much. Good afternoon.
Thank you. Goodbye.
Bye.